have been presented to the Senate at this point in this trial? How many pages of documentary evidence have been put in the record before the Senate in this trial? And how many other clips and transcripts of evidence have been presented to the Senate in this trial?
That's the first question of the afternoon session. And here comes the President's counsel to respond.
Mr. Chief Justice, Senators, thank you for that question. And I think it is important to recognize that because the House managers keep talking about the need for witnesses, you can't have a trial without witnesses. You've seen a lot of witnesses. There were 17 witnesses who were deposed and testified in public, 12 in public, 17 who were in closed hearings below. So far, you have seen in these presentations 192 video clips from 13 different witnesses. So testimony was shown here to you, just as you would in a trial in an ordinary court sometimes play the video of a deposition instead of having the witness take the stand. You've seen video clips from 13 different witnesses. The House managers have dramatically wheeled into the Senate a record. I think it was reported as being 29,000 pages. I think the more official number is 28,578 pages. So you've got over 28,000 pages of documents submitted into the record provisionally in evidence in this trial, subject later to potential objections for hearsay and other evidentiary objections. You've also heard here the arguments that have been presented along with the presentation of both the documentary and testimonial evidence by video clip and by slides that were put up. You've heard argument for up to 24 hours from each side. We didn't take all of our time, but the House managers argued for over 21 hours, putting on with their video clips and their excerpts from documents in the record, their case. So at this point, there has been a lot put on here in terms of a trial. You've seen the witnesses in the clips, all of the most relevant parts. You've seen the documents put up in excerpts on the screens. And as a result of this, the House managers have consistently said over and over again, before they came here, they said they had an overwhelming case. It was already buttoned down. They didn't need anything else. They said when they got here that it was proven. Every single allegation, every line in each article of impeachment, they said proven, proven, proven. We don't think that that's true, but that's their words. That's what they're telling you, that they've had sufficient evidence to make their case. They said proven, sufficient, uncontested, and overwhelming at least 68 times in the proceedings on the floor here. Manager Nadler told us just today that they think they've not only proved it beyond a reasonable doubt, but beyond any doubt because of the evidence that they've already put on in front of you. We don't think that's true. We think we've demonstrated it's not. But the point is that the House managers have already put on a substantial amount of testimony from witnesses through their clips of prior deposition or hearing testimony. They've already presented to you a large portion of the most relevant documents from those 28,000. You've heard from the witnesses. You've seen where their testimony conflicts. You can see which is the better, more persuasive version of the facts. You've been able to see what it is that they have in the record that they say was overwhelming, already ready to go to trial. And this proceeding, therefore, has already had a lot of the earmarks of a trial. So don't be taken in by the idea that we can't have a trial here. You can't have a valid proceeding unless they bring someone in here to testify live. Because it wouldn't be just one person. If we start to go down that route,
Let's do it.
It's not presenting the case that was prepared in the hearings below. It's opening up discovery for an entirely new case. And there'd have to be depositions and witnesses on both sides. And there's no need to do that if they really believe what they're telling you, that it's already overwhelming.
It is.
It's
We should
already
impeach.
proven.
We do believe that. You're the only ones who are defending a man.
There's no need to go on to anything else when you've already seen so much. And the House managers had their case chance to prepare their case. And again, I would also just make the point to bear in mind, what is the precedent set? What would the precedent be set if this chamber has to become the investigatory body for impeachments that were not prepared properly in the House? Thank you.
Thank you, counsel.
You lunatic man.
Mr. Chief Justice,
Senator from Arizona.
I submit a question to the desk for the President's Counsel on behalf of myself, Senators Manchin, Senators Murkowski, and Senator Collins.
Thank you. The question from Senator Sinema and the other senators for counsel for the president. The Logan Act prohibits any U.S. citizen without the authority of the United States from communicating with any foreign government with the intent to influence that government's conduct in relation to any controversy with the United States. Will the president assure the American public that private citizens will not be directed to conduct American foreign policy or national security policy unless they have been specifically and formally designated by the President and the State Department to do so?
Mr. Chief Justice, Senators, thank you for the question. Let me preface it, let me answer in several parts. The first is, I just want to make clear that there was no conduct of foreign policy being carried on here by a private person. The testimony was clear from Ambassador Volker, and I assume that the reference would be to Mr. Giuliani, the president's private counsel. Ambassador Volker was clear that he understood Mr. Giuliani just to be a source of information for the president and someone who knew about Ukraine and someone who spoke to the president. And in fact, it was the testimony that it was the Ukrainians, Andrei Yermak, who asked to be connected to Mr. Giuliani simply because he was someone who could provide information to the president. And Ambassador Volker testified that it was not his understanding, he did not believe that Mr. Giuliani was carrying out sort of policy directives of the president, but rather indicating his views of what he thought would be something useful for the Ukrainians to convince the president of their anti-corruption bona fides. So just wanted to make that point. It is, of course, the president's policy is always to abide by the law, by the laws. I'm not in a position to make pledges for the president here, but the president's policy is always to abide by the laws and would continue to do so. I think it is worth pointing out that many presidents, starting with President Washington, have relied on persons who are their trusted confidants, but who are not actually employees of the government, to assist in the conduct of foreign diplomacy. President Washington relied on Gouverneur Morris to carry messages in certain circumstances, I believe, to the French. FDR had his confidant who he relied on in certain circumstances to be a go-between with foreign powers, and there are a list of others. They were mentioned in some of the testimony during the House proceedings. So I don't think that there is anything, again, as I said, it was not here, but there would not be anything improper for a president in some circumstances to rely on a personal confidant to be able to convey messages or receive messages back and forth from a foreign government that would relate to the president's conduct of foreign affairs. That's not prohibited, but within his authority under the Constitution, under Article 2. Thank you.
Thank you, counsel. Senator from Illinois. Sorry.
Your Honor.
Senator from Louisiana?
Thank you, Your Honor. On behalf of myself and Senator Ernst, I send a question to the desk for Mr. Nadler and Mr. Philbin.
The question from Senator Kennedy and Senator Ernst for both parties. The House managers will be first. If a president asks for an investigation of possible corruption by a political rival under circumstances that objectively are in the national interest, should the president be impeached if a majority of the House believes the president did it for the wrong reason?
The president, of course, is entitled to conduct our foreign policy, is entitled to look into corruption in the United States or elsewhere, is entitled to use the Department of State or any other department for that purpose. He is not entitled to target an American citizen specifically, nor did he do so innocently here. It was only after Mr. Biden became an announced candidate for president that he suddenly decided Ukraine ought to look into the Bidens. And he made it very clear that he wasn't interested in an investigation. He was interested in an announcement of an investigation just so the Bidens could be smeared. So it's probably never suitable for a president to order an investigation of an American citizen. If he thinks there's general corruption and there's an investigation ongoing, the Justice Department can certainly ask a foreign government for assistance in that investigation, but that wasn't done here. The president specifically targeted an individual with an obvious political motive. And I would simply say that that is so clear that there's no question that it was a political motive against specific individuals. There are about 1.8 million companies in Ukraine. The estimates were that half of them were corrupt. The president chose one, the one with Mr. Biden.
Thank you, Mr. Manager.
Mr. Chief Justice, Senators, thank you for the question. I think the short answer is no, the president should not be impeached. And I think the focus of the question is getting at to a situation of mixed motives, which has come up a couple times here. If the president is chief law enforcement officer, head of the executive branch, is in a situation where there is a legitimate investigation to be pursued, and he indicates that it should be pursued, is it possible that he should be impeached for that if there's some dispute about his motives where there is a legitimate basis for that conduct? And the answer is no. And the House managers themselves, in the way they frame their case, have recognized this. In the House Judiciary Committee report, they repeatedly say that the standard they're going to have to meet, they're going to have to show that these are sham investigations. These are baseless investigations that they're alleging that the president wanted to initiate.
Not at
and that
all.
they had there was not any legitimate basis for pursuing the investigation. I'm pretty sure that's page 5 of the House Judiciary Committee report. And they use that standard, and they've talked about there not being a scintilla of evidence about anything that anyone could reasonably want to ask about related to the Bidens and Burisma, because they know that they can't get into a mixed motive scenario, because if you have a legitimate basis for asking a question about something, if there is a legitimate national interest there, it's totally unacceptable to start getting into the field of saying, well, we're going to impeach the president and remove him from office by putting him on the psychiatrist's couch and trying to get inside his head to find out, was it 48% this motive and 52% the other, or did he have some other rationale? No, if it's a legitimate inquiry in the national interest, That's the end of it. And you can't be saying that we're going to impeach the president, remove him from office, decapitate the executive branch of the government, disrupt the functioning of the government of the country in an election year by trying to parse out subjective motives and which percentage of the motive was this good motive or some other motive, something like that. If it's a legitimate inquiry in the national interest, if that possibility is there, if the national interest is there, that's the end of it. Thank you.
Thank you, counsel. I haven't specified this before, but I think it would be best if senators directed their questions to one of the parties or both and leave it up to them to figure out who they want to go up to bat rather than particular counsels. Senator from Illinois.
One of the rare moments where Chief Justice Roberts actually declared a simple statement on behalf of procedure. Earlier today, we did see him unusually not read a question. I'm not sure why that would have happened. I would like to ask that. That's something I would love to ask.
The question from Senator Durbin to the House managers. Would you please respond to the answer that was given by President's counsel to Senator Sinema's question?
I thought they already did.
Senator, Chief Justice, in answer to that question, we heard a rather breathtaking admission by the president's lawyer. And it was said in an understated way, and so you might have missed it. But what the president's counsel said was that no foreign policy was being conducted by a private party here. That is, Rudy Giuliani was not conducting U.S. foreign policy. Rudy Giuliani was not conducting policy. That is a remarkable admission, because to the degree that they have attempted to suggest or claim or insinuate that this is a policy difference, that a concern over burden sharing or something, corruption, was a policy issue, they have now acknowledged that the person in charge of this was not conducting policy. That is a startling admission. So the investigations that Giuliani was charged with trying to get Ukraine to announce into Joe Biden, into this Russian propaganda theory, they have just admitted were not part of policy. They were not policy conducted by Mr. Giuliani. So what were they? They were, in the words of Dr. Hill, a domestic political errand, not to be confused with policy. They have just undermined their entire argument, even as to mixed motives, because the man in charge of it was undergoing this domestic errand. Now, you heard a suggestion there. He was only doing this, Giuliani was only doing this because he was being asked by Andrei Yermak. That is laughable. Giuliani tried to get the meeting with Zelensky, remember? And he couldn't get in the door, and then he announced that there are enemies around President Zelensky. And then they go into that phone call on July 25th. Ukrainians try to persuade the president, you don't have enemies in Ukraine, we're only friends. And what's the president's response? I want you to talk to Rudy. That's not policy being conducted there. That's a personal political errand. They just undermined their entire argument. Now, the president's counsel also essentially argues in terms of witnesses, if their case is as strong as Mr. Schiff and Mr. Nadler and others say, then why do they need witnesses? You can imagine the scene in any courtroom in America where before the trial begins, defense counsel for the defendant stands up and says, Your Honor, if the prosecution case is so strong, let them prove it without witnesses. That's essentially what's being argued here. Well, I will make an offer to opposing counsel who have said that this will stretch on indefinitely if you decide to have a single witness. Let's cabin the depositions to 1 week. In the Clinton trial, there was 1 week of depositions. And you know what the Senate did during that week? They did the business of the Senate. The Senate went back to its ordinary legislative business while the depositions were being conducted. You want the Clinton model? Let's use the Clinton model. Let's take a week. Let's take a week to have a fair trial. You could continue your business. We can get the business of the country done. Is that too much to ask in the name of fairness? That we follow the Clinton model, that we take 1 week? I mean, are we really driven by the timing of the State of the Union? Should that be our guiding principle? Can't we take 1 week to hear from these witnesses? I think we can. I think we should. I think we must.
Manager,
Wow.
Mr. Chief Justice,
the senator from Alaska.
Chief Justice, I send to the desk a question submitted on behalf of myself and Senator Schatz directed to both the White House counsel and the House managers.
Thank you.
Impassioned words there once again from Adam Schiff, I have to say, and not on his own behalf. That's what's amazing.
Question from Senators Murkowski and Schatz directed to both parties. Would you agree that almost any action a president takes, or indeed any action the vast majority of politicians take, is, to one degree or another, inherently political? Where is the line between permissible political actions and impeachable political actions? Counsel will go first.
Interesting.
Mr. Chief Justice, Senators, thank you for that question. And I think that the question really hits the nail on the head. As I mentioned the other day, in a representative democracy, elected officials almost always have at least one eye looking onto the next election and how their actions, their policy decisions, their actions in office will be received by the electorate. And there's nothing wrong with that. That's good. It's part of the way representative democracy works. So having part of your motives being looking towards the next election, looking towards how that will affect electoral chances, that's part of the nature of elected office. And to start getting into motives about will this affect my prospects in the next election and calling that corrupt, and if you've got that as part of your motive, looking into whether you were doing something for electoral advantage and saying that's going to be a corrupt motive, will say that you can be charged for wrongdoing with that or impeached, is very dangerous, because there's almost no way to get inside someone's head and parcel out which percentage was one motive, which percentage was another motive. If you start down that path, it's totally amorphous. And this is part of the point that Professor Dershowitz was making and that we've made here a couple of times. This idea of impeaching a president on a theory of abuse of power that depends entirely on analyzing subjective motive. Because that's what the House managers have suggested, that we're assuming there is an act on its face that is legitimate, that is within the president's authority. It's not on its face in any way unlawful or unconstitutional, but solely based on motive, we're going to impeach him. And by saying that, well, if it was really directed at the next election, that's the corrupt motive. That's a very dangerous path, because there is always some eye to the next election. And it ends up becoming a standard so malleable that it really is a substitute for a policy difference. If we don't like your policy, we attribute you bad motive. And that's actually something that Justice Iredell warned about in the North Carolina ratifying convention. That if you base something just on motive because of what he called malignity of party, the other party will always attribute bad motives. Thank you.
I think the answer is yes, that public officials are inherently political animals. And I don't mean that in a derogatory term. They run for office, they hold office, they conduct acts as political figures. But if we look at what Hamilton had to say about the core of offenses that warrant the impeachment power, he talked about the crimes being political in character and the remedies being political in character, because we're not talking about imprisonment here. We're not talking about taking away someone's liberty. So we're talking about a political punishment for a political crime. Now, what's a political crime? Yes, everyone in office has a political motivation. But certainly that doesn't mean that we can't draw a line between corrupt activity that is undertaken, yes, for a political reason, and non-corrupt activity. Indeed, we have to draw that line. Let's show what Professor Dershowitz had to say about where we should draw the line.
And if a president does something which he believes will help him get elected in the public interest, that cannot be the kind of quid pro quo that results in impeachment. The fact that he's announced his candidacy is a very good reason for upping the interest in his son. If he wasn't running for president, he's a has-been. He's the former vice president of the United States. Okay, big deal. But if he's running for president, that's an enormous big deal.
So it is certainly true that when public officials take actions, they may have in mind when they make a policy judgment, what's the impact on my political career going to be, or what's the impact going to be on my reelection prospects? But that's a very different question than whether they can engage in a corrupt act to help their election, in this case, to get foreign help to cheat in an election. I think we can distinguish between the fact that political actors have political interests with what the president's defense would argue. And that is, if he believes it's in his reelection interest, then no quid pro quo is too corrupt. If we go down that road, there is no limit to what this or any other president can do. There's no limit to what foreign powers will feel they can offer a corrupt president to help their reelection, if that is the precedent we intend to establish.
Thank you, Mr. Manager. Senator from New Jersey. Thank you.
Sorry, we are watching the Senate impeachment trial. There's a little break in the action here.
The question for the House managers from Senator Menendez. The president was seeking investigations from a foreign power based partly on what Fiona Hill called, quote, a fictional narrative perpetrated and propagated by the Russian security services, end quote. The U.S. intelligence community has warned that the Russian government is already preparing to attack our election in 2020, and the president has said publicly he would welcome foreign interference in our elections. Why should Americans be concerned about foreign interference, and why does it matter that the president continues to solicit foreign interference in our elections?
Mr. Chief Justice, Senator, thank you for the question. Let's outline the facts that we do know about today. None of the 17 witnesses who testified as part of the House's impeachment inquiry were aware of any factual basis to support the allegations that it was Ukraine and not Russia that interfered in the 2016 election. FBI Director Christopher Wray, who was nominated by President Trump and confirmed by this body, stated as recently as this past December that we have no reason to believe that Ukraine interfered in the 2016 U.S. election. He stated, quote, we have no information that indicates that Ukraine interfered with the 2016 presidential election. President Trump's own Homeland Security advisor, Tom Bossert, said about this allegation, quote, it's not only a conspiracy theory, it is completely debunked, end quote. He added, quote, let me just repeat here again, it has no validity, end quote. And of course, Ms. Hill, as the question indicated, said, quote, fictional narrative that is being perpetrated and propagated by the Russian security services themselves. The U.S. intelligence community has unanimously determined that there's no validity to this. Our own intelligence and law enforcement. Special Counsel Mueller found that Russia's interference was, quote, sweeping and systematic. But don't take our own law enforcement and intelligence community's word for it. Let's hear what Vladimir Putin himself said recently about this. In November of 2019, Mr. Putin was overheard saying, quote, "Thank God no one is accusing us of interfering in the US elections anymore. Now they're accusing Ukraine," end quote. And let me end with that one, because that one demonstrates to me why this matters. That one demonstrates to me why anyone in the United States should matter. Vladimir Putin could care less about delivering health care for the people of Russia, for building infrastructure in Russia. Vladimir Putin, as many people in this chamber know well, because I've worked with some of you on this, wakes up every morning and goes to bed every night trying to figure out how to destroy American democracy. And he has organized the infrastructure of his government around that effort. This is a battle over resolve. It's the battle over the hearts and minds of our people. It's the battle over information and disinformation.
Yes, it is.
And if the message from the very top of our government, from the very top of our leaders, if the message from some folks over the last couple of weeks is that facts don't matter, that our law enforcement doesn't matter, that our intelligence community's unanimous consensus doesn't matter, that is dangerous. That is what Vladimir Putin and Russia are looking for, and that makes us less safe.
Thank you, Mr. Manager. Senator from Wisconsin.
Mr. Chief Justice, I send a question to the desk on behalf of myself and Senators Hawley, Cruz, Kramer, Braun, Perdue, Barrasso, Rubio, Risch, Sullivan, Ernst, Scott of Florida, Daines, and Fisher for both the House managers with response from the Council to the President.
Thank you. The question from Senator Johnson and the other senators for both parties. Recent reporting described 2 NSC staff holdovers from the Obama administration attending an all-hands meeting of NSC staff held about 2 weeks into the Trump administration and talking loudly enough to be overheard, saying, "We need to do everything we can to take out the president." On July 26, 2019, the House Intelligence Committee hired one of those individuals, Sean Misko. The report further describes relationships between Misko, Lieutenant Colonel Vindman, and an individual alleged as the whistleblower. Why did your committee hire Sean Misko the day after the phone call between President Trump and Zelensky? And what role has he played throughout your committee's investigation? The House will begin.
First of all, there have been a lot of attacks on my staff. And as I said when this issue came up earlier, I'm appalled at some of the smearing of the professional people that work for the Intelligence Committee. Now, this question refers to allegations in a newspaper article which are circulating smears on my staff and ask me to respond to those smears. And I will not dignify those smears on my staff by giving them any credence whatsoever, nor will I share any information that I believe could or could not lead to the identification of the whistleblower. I want to be very clear about something. Members of this body used to care about the protection of whistleblower identities. They didn't used to gratuitously attack members of committee staff, but now they do. Now they do. Now they'll take an unsubstantiated press article and use it to smear my staff. I think that's disgraceful. I think it's disgraceful. You know, whistleblowers are a unique and vital resource for the intelligence community. And why? Because unlike other whistleblowers who can go public with their information, whistleblowers in the intelligence community cannot, because it deals with classified information. They must come to a committee. They must talk to the staff of that committee or to the Inspector General. That is what they're supposed to do. Our system relies upon it. And when you jeopardize a whistleblower by trying to out them this way, then you are threatening not just this whistleblower, but the entire system. Now, the president would like that, nothing better than that. And I'm sure the president is applauding this question because he wants his pound of flesh. And he wants to punish anyone that has the courage to stand up to him. Well, I can't tell you who the whistleblower is because I don't know, but I can tell you who the whistleblower should be. It should be every one of us. Every one of us should be willing to blow the whistle on presidential misconduct. If it weren't for this whistleblower, we wouldn't know about this misconduct. And that might be just as well for this president, but it would not be good for this country. And I worry that future people that see wrongdoing are going to watch how this person has been treated, the threats against this person's life, and they're going to say, why stick my neck out? Is my name going to be dragged through the mud? Will people join our staff if they know that their names are going to be dragged through the mud?
Thank you, Mr. Manager.
Senate. There's two responses that I'd like to get to. One, with regard to the issue of witnesses, in this case, the whistleblower. Mr. Schiff put the whistleblower issue front and center with his own words during the course of their investigation. He talked about the whistleblower testifying. Retribution is what is prohibited under the statute against a whistleblower. That's what a whistleblower statute protects, that there's no retribution. In other words, they're not going to be fired for blowing the whistle. But this idea that there's complete anonymity, and I'm not saying that we should disclose the individual's name and you handle that in executive session or any way you'd want, but we can't just say it's not a relevant inquiry to know who on the staff that conducted the primary investigation here was in communication with that whistleblower, especially after Mr. Schiff denied that he or his staff initially had even had any conversations with the whistleblower. It goes back to the whole witness issue, and I want to go to that for just 30 seconds here. It seems to me that the discussion for witnesses, I heard what Mr. Schiff said about the 30, we'll do depositions in a week. The Democratic leader said I could have any witnesses I want yesterday. I've got it in the transcript. And you couldn't get all the witnesses you'd want in a week. You couldn't get the discovery done in a week. But if in fact they believe that they presented this overwhelming case that they have, they talk about subterfuge and smoke screens. The smoke screen here is that they used 13 of their 17 witnesses to try to prove their case, and we were able to use those very witnesses to undercut that case. So I think we just have to keep that in perspective. Thank you, Mr. Chief Justice.
Thank you, counsel.
Mr. Chief Justice.
The senator from Washington.
Thank you, Mr. Chief Justice. I send a question to the desk for the House managers.
Thank you. The question from the for the House managers from Senator Murray. If there are no consequences to openly defying a valid congressional subpoena, how will Congress be able to perform its constitutional oversight responsibility to make sure any administration is following the law and acting in the best interests of American families?
Well, they could have very serious, devastating, dire consequences. If the Senate ignores President Trump's ongoing obstruction of Congress, it would lead to the end of congressional oversight as we know it today. President Trump's attorneys argue that our congressional subpoenas are constitutionally invalid until a court determines otherwise. Their argument is false, and it is an attack on congressional oversight powers. A vote against Article 2 is a vote to condone President Trump's corrupted view of America's constitutional balance. Voting against Article 2 will grant President Trump and every other president from now until forever the power to simply ignore all congressional subpoenas unless and until we seek to a court to enforce it. Under President Trump's view, even if all of you senators were to vote to favor to issue a subpoena for documents or witnesses, the administration could still ignore that until a court ruled on it. I think Mr. Schiff addressed some of that earlier in another question. They could take us, you could go to court to enforce it, then it would get appealed, then go back to court. We could go on because quite frankly, that's what their position is. So again, as Mr. Schiff said earlier, imagine yourselves having jurisdiction over an item that you care deeply about, and you needed information. You heard of some wrongdoing. You heard there was a whistleblower complaint on something, and you decided that you wanted to do a hearing. It's very possible that the president would complain on something, and you decided that you wanted to do a hearing. It's very possible
Dang it, it's repeating.
that the president would just flatly refuse your subpoena. But we need you to issue a subpoena for us today, not only to get Mr. Bolton here, but Mr. Duffy, Mr. Mulvaney, and everyone else with relevant evidence on this case. Now, when the administration exerts executive privilege, there might be some privilege, one that is available to them on any of these documents. But those have to be asserted with every document as we send a subpoena. So don't buy the White House argument that our subpoenas are invalid because we don't have any authority to issue them. We know we do. You know we do. So let's make sure that this body will make sure that no future president will just simply defy, disrespect, and ignore subpoenas. Because someday you may be in our shoes wanting to get information, wanting to get to the bottom line to ensure that no president is above the law. Thank you.
Thank you, Ms. Manager.
Mr. Chief Justice.
The senator from Alaska.
Mr. Chief Justice, I sent a question to the desk on behalf of myself, Senators Risch, Blunt, Kennedy, and Johnson for the President's Council.
Thank you.
We are listening to the Senate impeachment trial of Donald J. Trump, the 45th President of the United States. The Chief Justice, John Roberts, is presiding, and he reads the questions as they are brought to him from the senators. There you see one of the pages walking up and handing him the question.
The question for Senator Sullivan and the other senators for counsel for the president. Given that the Senate is now considering the very evidentiary record assembled and voted on by the House, which Chairman Nadler has repeatedly claimed constitutes overwhelming evidence for impeachment, how can the Senate be accused of engaging in what Mr. Nadler described as a cover-up if the Senate makes its decision based on the exact same evidentiary record the House did?
Mr. Chief Justice, Senators, thank you for that question. And I think that's exactly right. I think it's rather preposterous to suggest that this Senate would be engaging in a cover-up to rely on the same record that the House managers have said is overwhelming. They've said it dozens of times. They've said that, in their view, they've had enough evidence presented already to establish their case beyond any doubt, not just beyond a reasonable doubt. And it's totally incoherent to claim at the same time that it would be improper for the Senate to rely on that record. Your judgment may be and should be, we submit, different from the House manager's assessment of that evidence because it hasn't established their case at all. But if they're willing to tell you that it's complete and it has everything they need, to establish everything they want, I think you should be able to take them at their word that that's all that's there. And the switch now to say, well, no, we need more witnesses, I think just demonstrates that they haven't proved their case. They don't have the evidence to make their case.
That's okay. Your idiocy.
And as I went through a minute ago, you know, they have already presented a record with over 28,000 pages of documents that's here. They've already presented video clips of 13 witnesses. You've heard all of the key evidence that they gathered. It was their process. They were the ones that said what the process was going to be, how it had to be run, who ought to testify, and when to close it, when to decide they had enough. And you've heard all the key highlights from that. And that is sufficient for this body to make a decision. If in the time I have remaining, I just want to turn to one point in response to something that was said a couple of minutes ago. And we keep hearing repeatedly today the refrain of the idea that President Trump was somehow trying to peddle Vladimir Putin's conspiracy theory, that it was Ukraine and not Russia that interfered in the 2016 election. And the House Democrats try to present this binary view of the world, that only one interfered in the 2016 election. And the House Democrats try to present this binary view of the world, that only one country and one country alone could have done something to interfere in the election, and it was Russia. And if you mention any other country doing something related to election interference, you're just a pawn of Vladimir Putin trying to peddle his conspiracy theories. That is obviously not true.
The Mueller report
More
found
than one country and foreign nationals from
Now you're
more
just
than one
talking
country
crazy.
could be doing different things for different reasons in different ways to try to interfere in the election. And that's exactly what President Trump was interested in. In the telephone call, the July 25th transcript, he mentions CrowdStrike, he mentions the server, but he talks about, he says, there are a lot of things that went on, the whole situation. I think you're surrounding yourself with some of the same people. So he's talking about much more than just the DNC server. And he closes it again saying, he refers to Robert Mueller's testimony. And he says, they say a lot of it started in Ukraine. There's just a lot of stuff going on. Twice in that exchange, he says, there's a lot of stuff, the whole situation. And what is that referring to? Surrounding yourself with the same people. President Zelensky refers immediately to changing out the ambassador, because the previous ambassador, who had been there under Poroshenko, had written an op-ed criticizing President Trump during the election. We also know that there was a Politico article in January of 2017 cataloging multiple Ukrainian officials who did things either to criticize President Trump or to assist a DNC operative, Alexandra Chalupa, in gathering information against the Trump campaign. And they said there was no evidence in the record. No one said that there was anything done by Ukraine. That's not true. One of their star witnesses, Fiona Hill, specifically testified in her public hearing because she said she went back and checked because she had Hillary Clinton winning the election, end quote. And so it was quite evident, in her words, that they were trying to favor the Clinton campaign, including by trying to collect information on people working in the Trump campaign. That was Fiona Hill. She acknowledged that Ukrainian officials were doing that. So this idea that it's a binary world, it's either Russia or Ukraine. If you mention Ukraine, you're just doing Vladimir Putin's bidding. It's totally false.
Interesting.
And you shouldn't be fooled by that.
So that's
The Ukrainians, various Ukrainians were doing things to interfere in the election campaign. And that's what President Trump was referring to.
Counsel,
that's amazing. So that's in the face of the entire
Senator from
intelligence community.
Vermont.
Mr. Chief Justice, I would ask to send a question to the desk on behalf of myself and Senator Blumenthal for the House managers.
Thank you, Senator.
That's incredible. That's incredible. So their opinion is that the Trump administration and Giuliani and the people they know more than the entire intelligence community, FBI, CIA, and Foreign Service. That's amazing.
The question
That's-
for the senator, for the House
that's
managers
gold,
from
my
Senator
friends.
Leahy and Senator Blumenthal.
That is
The
gold.
president's counsel claimed, quote, "If a president does something which he believes will help him get elected in the public interest, that cannot be the kind of quid pro quo that results in impeachment," end quote. He added a hypothetical, quote, "I think I'm the greatest president there ever was, and if I'm not elected, the national interest will suffer greatly. That cannot be an impeachable offense," end quote. Under this view, there is no remedy to prevent a president from conditioning foreign security assistance in violation of the Impoundment Control Act on the recipient's willingness to do the president a political favor. If the Senate funding from a U.S. city until that mayor endorses him, what would stop a president from withholding nearly any part of the $4.7 trillion annual federal budget subject to his personal political benefit?
Mr. Chief Justice, distinguished members of the Senate, I thank the senators for that very important question. Certainly, what we have alleged in this case is that the president solicited a personal political benefit in exchange for an official act, solicited dirt on a political opponent in exchange for the release of $391 million in military aid, solicited dirt in exchange for a White House meeting. And if this Senate were to say that's acceptable, then precisely as was outlined in that question could take place all across America in the context of the next election and any election. Grants allocated to cities or towns or municipalities across the country. But the president could say, "You're not going to get that money, Mr. Mayor, Mrs. County Executive, Mrs. Town Supervisor, unless you endorse me for re-election." President could say that to any governor of our 50 states. That's unacceptable. That cannot be allowed to happen in our democratic republic. Now, by my count, as of this afternoon, the framers of the Constitution and the founders of our great republic had been quoted either directly or mentioned by name 123 times. Alexander Hamilton, 48 times. James Madison, 35 times. George Washington, 24 times. John Adams, 8 times. Thomas Jefferson and Ben Franklin pulling up the rear 4 times. Seems to me that Ben Franklin and Thomas Jefferson need a little bit more love. And so let me try to do my part. Thomas Jefferson once observed that tyranny is defined as that which is legal for the government, but illegal for the citizenry. Legal for the government, but illegal for the citizenry. That's what we confront right now. President Trump corruptly abused his power. He targeted an American citizen, pressured a foreign government to try to cheat in the upcoming election. And the president's counsel would have you believe that is okay because he's the president of the United States. But our fellow citizens cannot cheat the Workers' Compensation Board by claiming a fake injury and escape accountability. Our fellow citizens cannot cheat the stock market by engaging in insider trading and then escape accountability. Our fellow citizens cannot cheat the college admissions process in order to get their child into an elite University and then escape accountability? Why should the President of the United States be allowed to cheat in the upcoming election and escape accountability? Tyranny is defined as that which is legal for the government and illegal for the citizenry. President's Counsel has suggested that President Trump can do anything that he wants and escape accountability. President Trump can solicit foreign interference in the upcoming election and escape accountability. He can cheat and escape accountability. He can engage in a cover-up and escape accountability. He can corruptly abuse his power, escape accountability, elevate his personal political interests, subordinate America's national security interests, and escape accountability. That's the Fifth Avenue standard of presidential accountability. I can do anything I want. I can shoot someone on Fifth Avenue and it doesn't matter. No, lawlessness matters. Abuse of power matters. Corruption matters. The Constitution matters.
Thank you, Mr. Manager.
Hakeem Jeffries.
Mr. Justice,
The Senator from Louisiana.
I send a question to the desk on behalf of myself and Senator Risch to both the House Manager and the White House Counsel. And although I cannot pick, ideally it would be Manager Lofgren.
We are listening to the Senate impeachment trial. The questions come to the Chief Justice there, and this time for the House managers.
The question from Senators Cassidy and Risch for both parties is as follows. In the Clinton proceedings, we saw a video of Manager Lofgren saying, quote, "This is unfair to the American people. By these actions, you would undo the free election that expressed the will of the American people in 1996. In so doing, you will damage the faith the American people have in this institution and in the American democracy. You will set the dangerous precedent that the certainty of presidential terms, which has so benefited our wonderful America, will be replaced by the partisan use of impeachment. Future presidents will face election, then litigation, then impeachment. The power of the president will diminish in the face of the Congress, a phenomenon much feared by the founding fathers," end quote. What is different now? If the response is that the country cannot risk the president interfering in the next election, isn't impeachment the ultimate interference? How does this not cheat those who did and or would vote for President Trump from their participation in the democratic process? I ask Manager Lofgren to address this question directly and to not avoid, as Manager Jeffers did, with a related question last night.
It's a good question.
Its counsel answers first.
Thank you, Mr. Chief Justice, members of the Senate. Well, as I've said before, I agree 100% with Manager Lofgren's comments from the past, and I think they should guide the Senate. There's really no better way to say it. What they're doing here, they keep falsely accusing the president of wanting to cheat when they're coming here and telling you, take him off the ballot in a political impeachment. Talk about cheating. You don't even want to face him. And let me say one more thing while I'm up here. I listened to Manager Schiff come up here and say he won't even dignify a legitimate question about his staff with a response, because he won't stand here and listen to people on his staff be besmirched who will join his staff. Since the beginning of this Congress, Manager Schiff, the other House managers, and others in the House have falsely accused the president, and they've come here and done it, the Vice President, the Secretary of State, the Attorney General, the Chief of Staff, lawyers on my staff, false accusations, calumny after calumny in dulcet tones. And that is wrong. And when you turn that around and say he will not respond to a legitimate question that I asked, it's a legitimate question. Who communicated with the whistleblower? Why were you demanding something that you already knew about? I asked him in another part of my October 8th letter that doesn't get a lot of attention from Mr. Schiff. I said, you have the full ability to release these documents on your own. No response. So I think you deserve an answer to that question. And I think it's time in this country that we stop assuming that everybody has horrible motives in the puritanical rage of just everybody's doing something wrong except for you. You cannot be questioned. That's part of the problem here. Thank you.
Thank you, counsel.
Why does this keep happening? Does anybody know the answer to that?
You know, I was a member of the House Judiciary Committee during the Clinton impeachment, and I was a member of the staff of a member of the Judiciary Committee during the Nixon impeachment. And during the Clinton impeachment, I found myself comparing what we were doing in Clinton to what we were doing or had done with Nixon. And here's what I saw, and I still see today. A special prosecutor started with Whitewater, spent several years until they found DNA on a blue dress. And they had a lie. The president lied about a sexual affair under oath, and that was wrong. It was a crime, but it was not a misuse of presidential power. Any husband caught would have lied about it. It was wrong, but it was not a misuse of presidential power. And so throughout the Clinton matters, I kept raising the issue that it was a misuse, and it turned out to be a partisan misuse of impeachment to equate a lie about a sexual affair to a high crime and misdemeanor. As Mr. Markey said, they rubbed out the word high and made it any crime and misdemeanor. That was what was wrong in the Clinton impeachment. Compared to the Nixon impeachment, where Richard Nixon engaged in a broad scope of ending the constitutional order, corrupting the government for his own personal benefit in the election. I would add, unfortunately, and I never thought I would be in a third impeachment. Unfortunately, that is what we see in this case with President Trump.
Ms. Manager. The senator from West Virginia.
Mr. Chief Justice, I send a question to the desk on behalf of myself, Senator Gillibrand, and Senator Schatz to the President's Council and the House managers.
Thank you. The question from Senators Manchin, Gillibrand, and Schatz for both parties. Have you ever been involved in any trial, civil, criminal, or other, in which you were unable to call witnesses or submit relevant evidence? I believe the House is first. The House is first.
Thank you, Mr. Chief Justice, and thank you to the senator for the question. I want us to imagine for just a moment, if someone broke into your house, stole your property, police caught them, they returned the property. Now, the fact that they returned the property changes nothing. They would still be held accountable. But imagine if they had the power to obstruct every witness, prevent witnesses from appearing. Imagine if they had the power to destroy or obstruct any evidence in the case against them from being presented to the court. I've had the opportunity to appear in a lot of hearings and be a part of building a lot of cases. And we all know, I know everybody here knows that witness testimony and evidence or documentation in a case is everything. It is the life and breath of any case. It is the prosecutor's dream, or the police officers or detectives' dream to have information and evidence. It truly baffles me, really, as a 27-year law enforcement officer, that we would not accept or welcome or be delighted about the opportunity to hear from direct witnesses, people who have firsthand knowledge. We know that the president cannot be charged with a crime. We know that the Department of Justice has already ruled on that. But the remedy for that is impeachment. That is the tool that, as we know, has solely been given, that power solely to the House of Representatives, solely tried before the Senate. So to answer your question, it is extremely, well, let me say it this way, only in a case where there are no available witnesses or no available evidence have I ever seen that occur. Thank you.
Mrs. Manager, counsel.
Thank you, Mr. Chief Justice, members of the Senate. I would respond to that question in this way, and thank you for the question. The House managers controlled the process in the House. I think we can all agree to that. They were in charge and they ran it. And they chose not to allow the President's counsel to have any witnesses. And they chose not to call the witness that they're now asking you to call, demanding you to call, accusing you of cover-up if you don't call. I've never been in any proceeding, trial or otherwise, where you show up on the first day and the judge says, let's go, and you say, well, I'm not ready yet. Let's stop everything. Let's take a bunch of depositions. Well, did you subpoena the witnesses you're now seeking?
Oops.
Well, some, but not others. Well, when you did subpoena them, did you try to enforce that subpoena in court? No. The other witnesses that you did subpoena, did they go to court? Yes. What did you do? I withdrew the subpoena and mooted out the case. And now I want them. I want them. Otherwise, you're doing the cover-up. Let me make another point, because they keep making this point. What will we do? The president's not producing documents. I'd like to refresh your recollection about the Mueller investigation. Okay. The Mueller investigation had 2,800 subpoenas, 500 search warrants, 500 witnesses. The president's counsel, the chief of staff, many, many others from the administration testified. Documents, voluminous documents were produced. And what happened? Bob Mueller came back with a conclusion. He announced it. There was no collusion. What did the House do? They didn't like it. Didn't like the outcome. So what did they do? They wanted a do-over. They wanted to do it all again themselves, despite the $34 million or more that were spent. So I don't think anybody really believes that the Trump administration hasn't fully cooperated with investigations. The problem is, when they don't like the outcome, they just keep investigating. They keep wasting the public's money because they don't really care about truth. They care about a political outcome. Thank you.
Thank you, counsel.
Mr. Chief Justice,
The senator from Utah.
I send a question to the desk on behalf of myself and Senators Hawley, Ernst, and Braun.
Thank you. The question for counsel for the president from Senator Lee and the other senators. Under the standard embraced by the House managers, would President Obama have been subject to impeachment charges based on his handling of the Benghazi attack, the Bergdahl swap, or DACA? Would President Bush have been subject to impeachment charges based on his handling of NSA surveillance, detention of combatants, or use of waterboarding?
Thank you, Mr. Chief Justice, members of the Senate. Under the standard, which is no standard, that they bring their impeachment to the Senate, any president would be subject to impeachment for anything. Presidents would be subject to impeachment for exercising longstanding constitutional rights, even when the House chose not to enforce subpoenas under their vague theory of abuse of power. I guess any president, as Professor Dershowitz, he had a long list of presidents who might have been subject to impeachment. So I'm not going to go through this particular incidents because I don't want to besmirch past presidents. I don't think the standard that they announce is helpful. I think it's very dangerous. I mean, you might want to get a lock on that door because they're going to be back a lot if that's the standard. Okay? And the truth of the matter is you don't have to look at anything. They're talking about witnesses. You don't have to look at anything except the articles of impeachment. I try to seek areas of agreement. I think we all agree that they don't allege a crime. That's why they spend all their time saying you don't need one. I remember one of the clips I showed where someone was saying with a lot of passion, they're trying to cross out high crime and make it any crime. Now they're trying to cross out crime, any crime. No crime is necessary. Okay? That's not what impeachment is about. This is dangerous. And it's more dangerous because it's in an election year. So yes, under the standardless impeachment, any president can be impeached for anything. And that's wrong. And they should be held, by the way, they should be held to their articles of impeachment. A lot of what they're trying to sell here, their own House colleagues weren't buying. They didn't make the articles of impeachment. Read the articles of impeachment. They don't allege a crime. They don't allege a violation of law. You don't need anything else except their articles of impeachment, your Constitution, and your common sense. And you can end this. Thank you.
Thank you, counsel.
And your common sense. And you can end this. Thank you.
Did it again. Thank you, counsel. The senator from Michigan.
Thank you, Mr. Chief Justice. I send a question to the desk on behalf of myself, Senator Cortez Masto, and Senator Rosen.
The question for the House managers from Senators Stabenow, Cortez Masto, and Rosen to both parties. In June 2019, Ellen Weintraub, then chair of the Federal Election Commission, wrote in a statement that, quote, "It is illegal for any person to solicit, accept, or receive anything of value from a foreign national in connection with the U.S. election. This is not a novel concept. Electoral intervention from foreign governments has been considered unacceptable since the beginnings of our nation," end quote. In a 2007 advisory opinion, the FEC found that campaign contributions from foreign nationals are prohibited in federal elections, even if, quote, "the value of these materials may be nominal or difficult to ascertain," end quote. How valuable would a public announcement of an investigation into the Bidens be for President Trump's re-election campaign? Begin with the White House counsel.
Mr. Chief Justice and Senators, thank you for the question. The idea that the Inspector General for the intelligence community wrote a cover letter on the whistleblower complaint, which he had actually exaggerated in the complaint, the idea that there was a demand for some assistance with the president's reelection campaign. That was forwarded to the Department of Justice. They examined it, and they announced back in September that there was no election law violation because they did not qualify as a thing of value. And I think that issue has been thoroughly examined by the Department of Justice here. And I just want to clarify one thing. The other day, yesterday, there was a question about information coming from overseas. And I was asked a question about that. And I want to be very precise that I understood a question to be about, was there a violation of a campaign finance law? Would there be one if someone simply got information from overseas? And the answer is no, as a matter of law. And think about this. If pure information, if information that came to someone in a campaign could be called a thing of value, if it comes from overseas, a thing of value is a prohibited campaign contribution. It's not allowed. If it comes from within the country, it has to be reported. So that would mean that anytime a campaign got information from within the country about an opponent or about something else that maybe would be useful in the campaign, they'd have to report the receipt of information as a thing of value under the campaign finance laws. That's not how the laws work. And there would be tremendous First Amendment implications if someone attempted to enforce the laws that way. So that's simply the point that I wanted to make. Pure information that is credible information is not something that is prohibited from being received under the campaign finance laws.
Thank you, counsel.
Mr. Chief Justice. I'm sorry, apologize.
Yes, Mr. Manager.
How valuable would it be for the president to get Ukraine to announce these investigations? And the answer is immensely valuable. And if it wasn't going to be immensely valuable, why would the president go to such lengths to make it happen? Why would he be willing to violate the law, the Impoundment Control Act? Why would he be willing to ignore the advice of all of his national security professionals? Why would he be willing to withhold hundreds of millions of dollars from an ally at war if he didn't think it was going to really benefit his campaign? You have only to look at the president's actions to determine just how valuable he believed it would be to him. Now, how would he make use of this? Well, if we look in the past, we get a perfect illustration of how Donald Trump would have made use of this political help from Ukraine. Let's look at 2016, when the Russians hacked the DCCC and the DNC, and they started dripping out these documents through WikiLeaks and other Russian platforms. What did the president do? Did he make use of it? Did he condemn it? Oh, he made beautiful use of it. Over 100 times in the last 3 months of the campaign, the president brought up time after time after time, rally after rally after rally, the Clinton Russian stolen documents. Now, we've had a debate since then. What was the impact of the Russian interference in 2016? In an election that close, was it decisive? No one will ever know. Was it valuable? You only have to look at Donald Trump's actions to know just how valuable he thought it was. He thought it was immensely valuable. And you can darn well expect that if he'd gotten his help from Ukraine, he'd be out there every day talking about how Ukraine was investigating Joe Biden. And Ukraine is conducting an investigation into Joe Biden. It would be proof of his argument against his feared opponent. You're darn right it would be valuable. What's more, it's illegal. And do we have to go through all the turmoil of the Russian interference to have the president do it all over again? One of the things that I found so significant, it was the day after Bob Mueller reached his conclusion that this president was back on the phone asking yet another country to help cheat in another election. You're darn right that would have been valuable.
Manager.
Mr. Chief Justice.
Senator from South Carolina.
I send a question to the desk on behalf of myself, Senators Cruz and Cornyn, for both parties.
Thank you.
We are listening to the ongoing Senate impeachment trial of Donald J. Trump. It is presided over by the Chief Justice of the Supreme Court. Chief Justice Roberts receives the questions and then he reads them as he will.
The question from Senators Graham, Cornyn, and Cruz is for both parties. When DOJ, he said their DOJ had a, quote, low threshold, end quote, to investigate. So the predicate here was the information that the FBI got at the end of July from the friendly foreign government, end quote. Why is the legal standard for investigating Trump so much lower than the standard for investigating Biden? And why was it okay to get the information from a, quote, friendly foreign government, end quote? The House managers are first.
Come on, buddy.
The Inspector General's report found that the investigation was properly predicated. That was the bottom line conclusion, that this was not a politically motivated investigation. The Inspector General also found, though, there were serious flaws with the FISA court process. There were serious flaws in how the FISA applications were written, in the information that was used, and prescribed a whole series of remedies, which the FBI director has now said should be implemented. But they found it was properly predicated. They found they did not have to ignore the evidence that had come to their attention, that the campaign for the president was having illicit contacts potentially, that it may be colluding or conspiring with a foreign power. Indeed, it would have been derelict for them to ignore it. But the argument, the implicit argument here is because there were problems, albeit serious problems, in the FISA court application involving a single person, that somehow we should ignore the president's conduct here. That somehow that justifies the president's embrace of the Russian propaganda. That somehow that justifies the president's distrust of the entire intelligence community. That somehow that justifies his ignoring what his own director of the FBI said, which his lawyers ignored today, which is there is no evidence that Ukraine interfered in the 2016 election. Because of a single FISA application against a single person and the flaws in it, you should ignore the evidence of the president's wrongdoing. Turn away from that. Let's not look at whether the president conditioned military aid and a White House meeting on help with an investigation. Let's look at flaws in how the FBI conducted a FISA application. The one does not follow from the other. The reality is that what you must judge here is, did the president commit the conduct he is charged with? Did the president withhold military aid and a coveted meeting to secure foreign interference in the election? And if he did, as we believe we have shown, does that warrant his removal from office? That is the issue before you, whether the FBI made one mistake or 5 mistakes with the FISA application.
Mr. Chief Justice, members of the Senate, let me actually answer the question. The Inspector General said, in a response actually from Senator Graham, when James Comey said he was vindicated by the Inspector General's report, the Inspector General said, no one who touched this
It's not an airstrip.
was vindicated.
You're out of your mind.
With regard to the FISA, you make so light, Manager Schiff, of what the FBI did. It wasn't a FISA warrant. There was an order unsealed just days ago saying that the process was so tainted by the Federal Bureau of Investigation, so tainted that not only was the NSD misled, but so was the FISA court. For those that don't know, that are watching, the FISA court, you can't blame the court on this, by the way. You have to blame the Federal Bureau of Investigation for allowing this to happen. That is the court that issues warrants on people that are alleged to be spies. There's no lawyers in those proceedings. There is no cross-examination. The court itself in its order said we rely on the good faith of the officers presenting the affidavits. Are there two standards for investigations? That is an understatement. But to belittle what took place in the FISA proceedings, frankly, Manager Schiff, you know better than that.
Thank you, counsel. Senator from Illinois.
Again, we're watching the Senate impeachment trial of Donald J. Trump, the 45th President of the United States.
Thank you. The question from Senator Durbin is to both parties. Emails between DOD and OMB officials reveal that by August 12, the Pentagon could no longer guarantee that all of the $250 million in DOD aid to Ukraine could be spent before it expired. Deputy Secretary of Defense Norquist drafted a letter that stated that the Pentagon had, quote, repeatedly advised OMB officials that pauses beyond August 19 jeopardize the department's ability to obligate USAI funding prudently and fully, end quote. Why did the president persist in withholding the funds when DOD officials were sounding the alarm that the hold would violate the law and shortchange our ally of needed military aid? It is the turn of the White House counsel to go first.
Mr. Chief Justice, Senator, thank you for that question. I think the thing to understand is there were a series of communications reflected, I believe, in the letter that OMB has sent to the GAO and in some of the testimony in the proceeding below that the Office of Management and Budget was encouraging DOD to take what steps it could to get everything lined up, have everything ready to obligate the funds, so everything would be able to move quickly when the pause was lifted. DOD, as the email you mentioned suggests, was saying, we're running out of time, we're running out of time, we're gonna have difficulty doing it. But the fact was that the deadline for obligating the funds was not going to be till the end of the fiscal year. And as it turned out, as I explained earlier in response to Senator Langford's question, funds were released on September 11th, and the vast majority of them were obligated by the end of the fiscal year. So that the procedures that had been used to try to get everything pre-planned were mostly successful. Yes, there was some funds, I believe it was $35 million, that did not get out the door by the end of the fiscal year, slightly more than in past years, but every year in fiscal year 2017, fiscal year 2018, there were funds in the security assistance program that didn't make it out the door by the end of the year. And in each of those years, there was also the little fix in either the next appropriations bill or the CR to allow those funds to carry over. So the planning had been to try to ensure that when the decision was made to release the funds, it would be done by the end of the fiscal year. Not quite all of it got out the door, that's true, but there is always some that doesn't get out the door by the end of the fiscal year. Thank you.
Thank you, counsel.
Mr. Chief Justice, members of the Senate, thank you for that question. You know, as we go further and further down this rabbit hole, I think we need to make it very clear that, you know, of the 17 witnesses that the House interviewed, nobody had an explanation. And yet, again, like last night, Mr. Philbin seems to know more than anybody else in the government, more than anyone in the Department of Defense, more than anybody in the Department of State, more than anybody in the OMB who would come forward with information about how exactly this happened. But again, here are the facts. OMB interviewed about an interagency process that they supposedly said was going on long after the interagency process had already ended. In fact, as OMB was doing those footnotes that we talked about last week, those footnotes that had never been done before, that Mr. Sandy said he had never seen in his 12 years plus of time working this process. As that was going on, DOD was asking the question about why we are doing this. They had no idea. And then when the release was finally getting ready to be finally lifted, the hold rather, OMB emailed DOD saying, listen, as we've been saying all along, under the Impoundment and Control Act, there are no problems here, and if there is a problem, it's your fault. To which DOD replied back, as you may recall, you got to be kidding me. I'm speechless, because they did not know. Nobody had told them anything. None of the other 17 witnesses knew about it. So I do want to address, before I finish, one other point. This idea that the delay didn't matter. Listen, it doesn't matter if it was a 4-day delay, a 40-day delay, or a 400-day delay. Every delay in combat matters. Every delay in combat matters. And I will say, they talked about delays in the past. Well, in past years, there was about 3 to 6% of the funds unobligated because of unforeseen and legitimate reasons following the policy process. In 2019, 14% of the funds went unobligated for foreseeable and unavoidable reasons, because the president could have held them. And to this day,
Thanks,
16
Mr. Manager.
million
Your
is
time has
unspent.
expired.
Mr. Chief Justice.
The senator from Wyoming.
Thank you, Mr. Chief Justice. I send a question to the desk on behalf of myself and Senators Risch, Young, Fisher, Blunt, and Capito.
Thank you. The question from Senator Barrasso and the other senators is for the counsel to the president. Is it within a U.S. president's authority to personally address the issue of corruption with a head of a foreign government when he believes the established U.S. process has been unsuccessful in the past?
Mr. Chief Justice and Senators, thank you for that question. The short answer is yes. The president is under Article 2 vested with the entirety of the executive power. And it has been made clear since the founding, since the early part of the 1800s in decisions by the Supreme Court, that the president is the sole organ of the nation in foreign affairs. He is vested with the authority to speak on behalf of the nation, as the Supreme Court has described it. He is to be the sole voice of the nation in foreign affairs. And that is why that authority was assigned in the Constitution to the executive. Alexander Hamilton has explained in the Federalist Papers that the executive is characterized by unity and dispatch, the ability to have one view, to act quickly, and also the ability to maintain secrecy. And therefore, it is the executive that is uniquely suited and then uniquely has the ability to carry out the responsibilities of engaging with foreign nations and carrying out diplomacy. So when the president believes that there's an issue of interest to the United States, including corruption in another country, and there hasn't been the sort of progress that he would want to see in dealing with that issue in the foreign country, perhaps interactions with prior administrations, prior officials of prior administrations that don't look great from an anti-corruption perspective, it is entirely within the president's prerogative and within his province to raise those issues with a foreign leader, to point out where he believes that there needs to be something done in the interest of the United States, that if there is an issue related to corruption, or whether it's something else, an issue related to economic matters, trade matters, antitrust matters, cross-border trade. Those are all things that the president can raise with a foreign leader. Corruption is not taken off the table, and it's also not taken off the table if it's an issue that happens to involve an official from a prior administration whether that official is not or may have recently decided to run for another office. If it relates to the national interest of the United States, he has a legitimate reason for raising it, and it's within his authority as the chief executive. Thank you.
Pretty good argument there.
Thank you, counsel.
Mr. Chief Justice.
Senator from Massachusetts.
Mr. Chief Justice, I send a question to the desk.
Thank you.
Again, we're watching the Senate trial on the impeachment of Donald Trump.
The question from Senator Warren is for the House managers. At a time when large majorities of Americans have lost faith in government, does the fact that the Chief Justice is presiding over an impeachment trial in which Republican senators have thus far refused to allow witnesses or evidence contribute to the loss of legitimacy of the Chief Justice, the Supreme Court, and the Constitution?
Senator, I would not say that it contributes to a loss of confidence in the Chief Justice. I think the Chief Justice has presided admirably. But I will say this. I was having a conversation the other day on the House floor with one of my colleagues, Tom Malinowski from New Jersey, a brilliant colleague. And I was hearkening back to what I thought was a key exchange during the course of this, a brilliant colleague. And I was hearkening back to what I thought was a key exchange during the course of this saga. This is when Ambassador Volker in September is talking with Andrei Yermak. And Volker is making the case that the new president of Ukraine should not do a political investigation and prosecution of the former president of Ukraine, Poroshenko. And he's making the case that we often make when we travel around the country, we meet with other parliamentarians, about not engaging in political investigations. And when he makes that remark, Yermak throws it right back in his face and says, oh, you mean like the investigation you want us to do of the Clintons and the Bidens? And I was lamenting this to my colleague. What is our answer to that? What is the answer to that from a country that prides itself on adherence to the rule of law? How do we answer that? And his response, I thought, was very interesting. He said, this proceeding is our answer. This proceeding is our answer. Yes, we are a more than fallible democracy, and we don't always live up to our ideals. But when we have a president who demonstrates corruption of his office, who sacrifices the national interest for his personal interest, unlike other countries, there's a remedy. And so, yes, we don't always live up to our ideals, but this trial is part of our constitutional heritage, that we were given a power to impeach the president. I don't think a trial without witnesses reflects adversely on the Chief Justice. I do think it reflects adversely on us. I think it diminishes the power of this example to the rest of the world. If we cannot have a fair trial in the face of this kind of presidential misconduct. This is the remedy. This is the remedy for presidential abuse. But it does not reflect well on any of us. If the prosecution case is so good, why don't they prove it without any witnesses? That's not a model we can hold up with pride to the rest of the world. And yes, Senator, I think that will feed cynicism about this institution. That we may disagree on the president's conduct or not, but we can't even get a fair trial. We can't even get a fair shake for the American people. We can't, oh my God, we can't hear what John Bolton has to say. God forbid we should hear what a relevant witness has to say. Hear no evil. That cannot reflect well on any of us. It's certainly no cause for celebration or vindication or anything like it. Now, my colleague says that I'm a Puritan who speaks in dulcet tones. I think that's the nicest thing he's ever said about me. I wouldn't describe myself as a Puritan, but yes, I do believe in right and wrong. And I think right matters. I think a fair trial matters. And I think that the country deserves a fair trial. And yes, Senator, if they don't get that fair trial, it will just further a cynicism that is corrosive to this institution and to our democracy.
Thank you, Mr. Manager.
Chief Justice,
Senator from Alabama.
I send a question to the desk.
Thank you. The question from Senator Shelby is for the counsel for the president. Though not charged in the articles of impeachment, House managers and others have stated the president's actions constituted criminal bribery. Can this claim be reconciled with the Supreme Court's unanimous decision in McDonnell versus United States?
Mr. Chief Justice, Senator, thank you for that question. And I think the answer is no, it can't be reconciled with the McDonnell case. And let me make a couple of points in my answer. The first is, of course, because there is no bribery or extortion charge in the articles of impeachment, the managers can't rely on that now to try to establish their case. I pointed out yesterday, I believe, that that is a due process violation of the most fundamental sort, to have a charging document and leave out certain charges in the charging document, then come to trial and say, well, it's not in the indictment, it's not in the charge, but actually what we've shown you is he did something else wrong. It was this crime. As the House managers well know, that would result in an automatic mistrial in any actual trial in a court in this country. So that's the initial problem with trying to go there on bribery or something else. Then, as the senator's question raises, the McDonnell case made clear that simply arranging a meeting for someone, simply setting up a meeting with other government officials, couldn't be treated as the thing of value in an exchange under the bribery statute. And it pointed out particularly in terms of government officials who all the time are asked by their constituents to introduce them to someone else in the government, to arrange a meeting, that is not an official act. It's not an official policy decision, an action that is determining some government policy. It's simply allowing someone to have a meeting to then talk about something. If that's the nature of the meeting, that can't be the thing of value that is being exchanged and can't support a charge of bribery. So they can't raise it because it's not in the articles of impeachment. If they had wanted to charge that, they had to charge it in the articles of impeachment. They can't come here now and try a different case from the one they framed in the charging document that they had complete control over drafting. Even if they did, they can't make out the claim with respect to the White House meeting, because the McDonnell case prohibits that. I'd like to make one other point, because the House managers today have brought up a lot. There have been a lot of questions again and again about the subpoena power and whether subpoena is actually valid and how it's going to destroy oversight if the president's arguments are accepted. I just want to point something out. The subpoenas that were issued purported to have been issued not under oversight authority, but pursuant to, every letter that came out said pursuant to the House's impeachment inquiry. They purported to be exercising the authority of impeachment. And that makes a difference, because one of the House managers mentioned this: legislative oversight, the authority to inquire into information for legislative purposes, has to actually relate to something that legislation could be passed on. There's certain constraints on what information could be sought. Slightly different if you're going under the impeachment power, because then you can investigate into specific past facts more readily, because that's relevant to an impeachment inquiry that might not be for legislative purposes. They purported to be using the impeachment authority. They didn't have that authorization because the Speaker's press conference did not validly give them that authorization. We pointed out that the subpoenas were invalid. They did nothing to try to cure that deficiency. They didn't reissue the subpoenas. They didn't have the vote and reissue them or anything. And to say now that all of oversight will be destroyed forever if you accept the president's arguments, is totally false. It's totally misleading because they weren't purporting to do just regular oversight. And as we pointed out several times, the October 8th letter that the White House counsel sent to Chairman Schiff and others said specifically, if you want to return to regular oversight, we're happy to do that. As we have in the past, subject to constitutional constraints, we'll participate in the accommodations process. And it was the House Democrats that didn't want to take that route. So they insist on using the impeachment authority. We pointed out that they didn't have it, and they didn't seek to cure that problem. So accepting the president's position here has nothing to do with destroying oversight by Congress for all time and all circumstances. It has to do with the mistake that they made in trying to assert a particular authority that they didn't have in this case. Thank you.
Thank you, counsel.
Mr. Chief
The
Justice.
senator from Virginia.
Mr. Chief Justice, on behalf of myself, Senator Bennett, Senator Blumenthal, and Senator Heinrich, I have a question sent to the desk for the House managers.
Thank you. The question from Senator Warner and the other senators is for the House managers. Our intelligence community and law enforcement leadership unanimously concluded Russia interfered in the 2016 election and that Russia continues those efforts toward the 2020 election. The Mueller report and the Senate Intelligence Committee reached the same conclusion. Yesterday, the President's counsel said that foreign election interference could be legal if it's related to credible information. Does this mean it is proper for the President to accept or encourage Russia, China, or other foreign countries to produce damaging intelligence or information targeting his domestic political opponents as long as he deems it to be from credible information? For the House managers.
Senators, Justice, that is the natural conclusion of what the president's lawyers are arguing. Essentially, that if the president believes that it would serve his reelection interest to seek the help of a foreign intelligence service to provide dirt on his opponent or in other ways assist his campaign, as long as he thinks his winning is in the national interest, then that's okay. It's not only okay, but no restraint can be placed upon it. Even if he were to go so far as to proclaim a quid pro quo. Hey, Russia, you've got among the best intelligence services on the planet. If you will engage those intelligence services on my behalf, I will refuse to enforce sanctions on you over your invasion of Ukraine. That may injure the security of our country, but look, I think my reelection is more important. That's where this bastardization of the Constitution leads us. The idea that no abuse of power is within the reach of the Congress. Now, I want to take this opportunity to respond to a couple other quick points, if I can. First, counsel neglects the fact that when we issued those subpoenas, we stated in the letters accompanying their issuance that they were being issued consistent with both the impeachment inquiry and our oversight authority. They neglected to tell you the latter part, that we explicitly made reference to our oversight capacity as legislators. And finally, on the issue of bribery. In the Nixon impeachment, there was an umbrella article of impeachment that listed a series of specific acts. Some of those acts involve criminal activity and some involve just unethical activity. If you accept counsel's argument, you would have said that the articles passed out of the House Judiciary Committee in Nixon were likewise infirm, because if they were going to charge the president with engaging in a criminal act, they needed to make a separate article of it. And otherwise, how dare they, would be a violation of due process to be thrown out of any court, prosecutorial misconduct, and the like. Okay, that's nonsense. On the one hand, they want to argue there's no conduct here that's even akin to a crime. When under McDonald, in fact, this would constitute bribery, withholding a White House meeting, withholding the provision of hundreds of millions of dollars in aid under the precedent of McDonald, that would be bribery. But there's no doubt it's akin to bribery. But they say unless you charge that, unless in the Nixon case, they had 15 articles on each particular act, criminal and non-criminal, that you could not make out a viable charge. That's never been a constitutional principle. Just as they would have had the House organize its impeachment investigation along the terms they dictate, they now want to dictate how we can charge an offense. At the end of its impeachment investigation, along the terms they dictate, they now want to dictate how we can charge an offense.
Sorry, it keeps doing
At
that.
the end of the day, the task is to determine whether the conduct that's charged has been committed and whether that abuse of power rises to the level warranting impeachment. But this technical legal argument that, no, you have to charge it as we would like you to charge it, that you can't make reference to the fact that, yes, these acts also constitute bribery, that that's somehow offensive to legal or constitutional principles. It's not. Yes, we could have charged bribery. We could have had two separate counts. That is not a constitutional requirement. And had we done that, as I said last night, they would have attacked that, saying you're taking one offense and making it into two. That does not detract from the fact that the president's conduct violated our bribery laws, particularly as they were understood by the framers, not as they were understood 200 years later. They violated what the framers understood from British common law to constitute extortion. They violated the modern day Impoundment Control Act. They violated the Whistleblower Protection Act. They violated multiple laws, but that's not even necessary.
Thank you.
What is necessary is that they abuse their power. And counsel says, well, claims are made of abuse of power all the time. Yes, that's true in political rhetoric. But these circumstances warranted impeachment. The president was not impeached over climate change or any of the other innumerable examples they gave of people rhetorically saying the president is abusing his office. That's not what brought us here. What brought us here was the president decided that he could withhold military aid to an ally at war to get help in his reelection.
Thank you, Mr. Manager. The Senator from Oklahoma.
Question for the president's counsel.
Vertical.
A question from Senator Inhofe, joined by Senators Rounds and Young, for counsel to the president. Even if additional witnesses are called, do you ever envision the House managers agreeing there has been a fair Senate trial if it ends in the president's acquittal?
Mr. Chief Justice, members of the Senate, the answer is no. Now, they will not agree that it's fair because what will happen is if there's a discussion of witnesses, and if we go to witnesses, Mr. Schumer's laid out the four he wants. Now he tells me I can have anybody, we can have anybody we want. But the reality is that also includes documents. And that includes other witnesses that it may lead to. So at some point you'll say, because this cannot go on forever and we will be at the election, this body will say, this has to come to an end. And they will say, aha, it's been brought to an end as we were about to get the key evidence. But what is so interesting here is they had 17 witnesses that they had. When the hearing took place before the Judiciary Committee, if I'm not mistaken, Manager Nadler, you had 4 witnesses, I think, at one point, when you had the law professors. And there was 3 law professors from the Democratic side, and there was 1 from the Republican side.
What does that even
So if we're
mean?
going to take that same 4-to-1 analysis for every one of their
That's
witnesses.
3 to 1.
we
You
should
already
get
lied
4.
within the statement.
But there was a question earlier asked about the fruit of the poisonous tree. The taint of the poison does not age well. The longer it goes, does not make that poison go away. It gets deeper and deeper into the soil. And here the soil we're talking about is a trial that would be not only ongoing, but they put up 17 witnesses. You heard them. They're acting like there's been no witnesses presented here. They presented testimony, 17. They may not have liked that we were able to respond to those 17 by playing those witnesses' words. By the way, those witnesses, the testimony of those witnesses were never done with the cross-examination by the counsels for the president. So does this end? Will it ever be enough? No, it'll only be enough if they got a conviction. Because that's what it's about. Because let's not forget for a moment, this has been going on in one stage or another for 3 years now. My concern is where's the end point in that? So their end point is, well, just give us John Bolton, and then, you don't get anybody, or you get one and we get one, and then that one may lead to somebody else. It's not the way it works. So they've said overwhelming, proved 63 times. 63 times. And as we're 3 hours away from answering the question section, we're about to go into it sounds like we've been arguing about witnesses for the last couple of hours, but that starts tomorrow. But do I think that is it our position that there will be a recognition that there's due process has been reached and we've reached the happy accord? No, I do not believe that. I also don't believe that what can be cured here. I don't think what they did can be cured by anything you were to do as far as witnesses or anything else. That process was so tainted. I thought Mr. Philbin did a very effective job of explaining painstakingly now, and multiple times I know, the issue of those subpoenas. And I thought the perfect analysis was when one of the managers said, well, when people file Freedom of Information Act requests, they get answers. Mr. Philbin said that's because they followed the law. They followed the rules. That is not what happened here. Thank you, Mr. Chief Justice.
Thank you, counsel.
Mr. Chief Justice.
Senator from Delaware.
Chief Justice, on behalf of our colleagues, Senators Booker, Cardin, Kane, Markey, Menendez, Merkley, Murphy, and Shaheen, I send a question to the desk for our House managers.
Thank you.
Thank
We're getting close to the 2-hour mark. This may stop working again, and if it does, I'll start it. This is the Senate trial for impeachment.
Question from Senator Carper and the other senators addressed to the.
Yep, there it is. Just as I predicted. Are you still there? Resume playback. Authentication in progress. C-SPAN. Created by cable in 1979.
C-SPAN, your unfiltered view of government, created by cable in 1979.
The U.S. uses foreign assistance to achieve foreign policy goals and national security objectives, and how should we evaluate the defense argument that this is what is, quote, done all the time, end quote?
Mr. Chief Justice, Senators, thank you for the question. So to understand the answer to this, you don't have to look inside the president's mind. You just have to look at recent history and then what was done last year. As I talked about earlier and even yesterday, other presidents have holds an aid for legitimate reasons, even this president. We concede that there are a variety of legitimate policy reasons for holding aid, whether it be corruption or burden sharing. So even in the president's other holds, like Afghanistan, because of concerns about terrorism, or Central America, because of immigration concerns. And even though some might disagree with that, that is a legitimate policy debate. The difference here is that every witness testified, these 17 witnesses that you hear about, testified that there was no reason provided for the implementation of this hold. Right, I talked about earlier how there is a process for doing this, right? There is a well-prescribed process for allocating the funds, like we all did here in this chamber, and 87 of you agreed on. And then an interagency process to review it to make sure that it meets the standards and criteria outlined by this body, anti-corruption reforms. And that was done in this case. That interagency process was followed. That certification was made. The notification to Congress was conducted. The train had left the station, just like the train had left the station in 2018, in 2017, in 2016. And every element of the agencies and the bureaucracy involved in that process in prior years had been engaged and had signed off. Except this year, in 2019 rather, that all changed. A hold was implemented for no known reason. There was no notification given to Congress, which violated the Impoundment Control Act.
Thank you.
DOD, Department of State, Secretary Esper, Secretary Pompeo, even Vice President Pence, and the entire National Security Council implored the president to release the aid because it not only had met all of the certifications, but it was in the U.S. national interest and consistent with U.S. policy. And yet, nobody knew why it happened. And to this day, the individual who could shed light on this, Mr. Bolton, is being prohibited from coming forward to explain why the president told him it happened. So yes, it is still a good time to subpoena Ambassador Bolton and get that information.
Thank you, Mr. Manager. The senator from North Carolina.
Chief Justice, I have a question for both sets of counsels, sponsored by myself, Senator Cruz, Senator Scott of South Carolina, Hawley, Sass, and Rubio.
Thank you. The question from Senator Burr and the other senators is for both parties. The House will answer first. Hillary Clinton's campaign and the Democratic National Committee hired a retired foreign spy to work with Russian contacts to build a dossier of opposition research against her political opponent, Donald Trump. Under the House manager's standard, would the Steele dossier be considered as foreign interference in a U.S. election, a violation of the law, and/or an impeachable offense?
Thank you, Mr. Chief Justice and distinguished senators. I thank you for the question. The analogy is not applicable to the present situation because, first, to the extent that opposition research was obtained, it was opposition research that was purchased. But this speaks to the underlying issue of the avoidance of facts, the avoidance of the reality of what President Trump did in this particular circumstance. Now, I have tremendous respect for the President's counsel, but one of the arguments that we consistently hear on the floor of this Senate, this great institution in America's democracy, is conspiracy theory after conspiracy theory after conspiracy theory. We've heard about the deep state conspiracy theory. We've heard about the Adam Schiff is the root of all evil conspiracy theory. We've heard about the Burisma conspiracy theory. We've heard about the CrowdStrike conspiracy theory. We've heard about the whistleblower conspiracy theory. It's hard to keep count. This is the Senate. This is America's most exclusive political club. This is the world's greatest deliberative body. And all you offer us is conspiracy theories because you can't address the facts in this case that the president corruptly abused his power to target an American citizen for political and personal gain. He tried to cheat in the election by soliciting foreign interference. That is an impeachable offense. That is a crime against the Constitution. That is the reason that we are here. That is what is before this great body of distinguished senators.
Thank you, Mr. Manager.
Mr. Chief Justice, members of the Senate. So I guess you could buy, that's what it sounds like. You can buy a foreign interference. You could, if you purchase it, you purchase their opposition research, I guess it's okay. So let me try to debunk the conspiracy, Manager Jeffries, and that is, it is not a conspiracy that Christopher Steele was engaged to obtain and prepare a dossier on the presidential candidate for the Republican Party, Donald Trump. It is not a conspiracy that Christopher Steele utilized his network of assets, including assets apparently in Russia, to draft the dossier. It is not a conspiracy that the dossier was shared with the Department of Justice through Bruce Orr, who was the number 4 ranking member of the Department of Justice at that time, because his wife, Nellie Orr, happened to be working for the organization Fusion GPS that was putting the dossier together. This is also not a conspiracy. It sounds like one, except it's real. And it's also not a conspiracy that that dossier, purchased dossier, was taken by the FBI, submitted to the Foreign Intelligence Surveillance Court to obtain a foreign intelligence surveillance order on an American citizen. It is also not a conspiracy that that court issued an order, 2 of them now, condemning the FBI's practice and acknowledging that many of those orders were not properly issued. None of that is a conspiracy theory. That's just the facts. Thank you.
Thank you, counsel. Senator from Wisconsin.
Mr. Chief Justice, I send a question to the desk for both President's Counsel and House Managers.
Thank you.
Again, we are covering.
Question from Senator Baldwin is for both parties, and counsel for the president will answer first. Can you assure us that the Jennifer Williams document submitted to the House was not classified secret for any reasons prohibited by Executive Order 13526, such as preventing embarrassment to a person? If yes, please describe or identify the serious damage to national security that would be caused by declassifying this document pursuant to the same executive order.
Mr. Chief Justice and Senator, in response to your question, the Trump administration's policy is always to abide by the requirements for classification of material. And the classification, my understanding is that that document is derivatively classified because it refers to another document, a transcript that was originally classified. I can't represent to you the specific reasons that the classification officer classified that document, but I can tell you that it was originally classified according to proper procedures. It is a properly classified document because that is the policy of the administration to follow the classification procedures. The memorandum that she submitted is derivatively classified because of that transcript. Now, that transcript relates to a conversation with a foreign head of state. Almost all conversations with foreign heads of state are classified. And they're classified because the confidentiality related to those communications is important for ensuring that there can be candid conversations with foreign heads of state. The president took an extraordinary action in declassifying 2 of his conversations with foreign heads of state, unprecedented, because he carefully weighed the balance of what was at stake in this case and the need for transparency for the American public in those 2 conversations. But that was an exception to the usual rule that such conversations are properly classified.
Thank you, counsel.
Again, we are covering the
I would encourage you, if you haven't already had the opportunity, to read that document for yourself and ask you whether you think there's any legitimate basis to classify that supplemental testimony. Now, the vice president has said that he had no knowledge of this scheme. He's denied any knowledge, involvement in any way, shape, or form. We heard the testimony of Ambassador Sondland that Ambassador Sondland raised with the vice president that the aid was being held up and was tied to these investigations. And the vice president didn't say, "What are you talking about? That could never be." The president would never allow such a thing. There was nothing but a silent nod of acknowledgement with what he was being told. But nonetheless, the vice president says that he knew nothing. And the vice president points to the open testimony of Jennifer Williams to support that contention. But the classified submission goes to that phone call between the vice president and President Zelensky. You should read that and ask yourself whether that submission is being classified because it would either embarrass or undermine what the president and the vice president are saying, or there's some legitimate reason. Now, the vice president at one point said that he wanted to release the record of his call. He certainly talked all about this issue, as has the president. If it was so classified, then why are they all talking about it? But we are to be assured that this classification decision was made absolutely above board. I'm sure that John Bolton's manuscript will be treated with the same rigid, objective scrutiny. You read that, don't take my word for it. You read that and you ask yourselves, is there anything that other than avoiding evidence that the administration doesn't want you to see, that the public shouldn't see Jennifer Williams' supplemental testimony? I don't think you can conclude that it is, except that it would be inconsistent with what you're being told and what the American people are being told. Well, they deserve the whole truth, and that's part of the truth. So let the public see it.
Mr. Manager.
Mr. Chief Justice.
The senator from Tennessee.
Thank you, Mr. Chief Justice. I send a question to the desk on behalf of myself, Senator Daines, and Senator Cruz.
Thank you.
Once again, we are covering the impeachment trial of Donald J. Trump, the 45th president of the United States. Every once in a while, these Republicans send up these questions that are really crazy. And if you notice, every single time, Ted Cruz is among them. Ted Cruz is a national embarrassment. At any rate, here comes the next question.
The question from Senators Alexander, Daines, and Cruz is for the House managers. Compare the bipartisanship in the Nixon, Clinton, and Trump impeachment proceedings. Specifically, how bipartisan was the vote in the House of Representatives to authorize and direct the House committees to begin formal impeachment inquiries for each of the 3 presidents?
Mr. Chief Justice and Senators, in the Nixon impeachment, we look back and we think about the vote on the House Judiciary Committee that ended up bipartisan, but it didn't start that way. The parties were as dug in as parties are today. The Republicans and Democrats saw it differently. But as the evidence emerged, a bipartisan consensus emerged on the committee, and a number of Republicans, Tom Railsback, who just passed away, Caldwell Butler, who loved Richard Nixon. He was a huge fan of Richard Nixon, but they couldn't turn away from the evidence that their president had committed abuse of power, cheat in the election, and that they had to vote to impeach him. When it came to the Clinton impeachment, that was, again, it started out along very partisan lines, and it ended along partisan lines. And I believe the reason why, as I said a short while earlier, was that we never had a high crime and misdemeanor. That was the problem. With Nixon, we had clear abuse of presidential authority to upend the constitutional scheme, to cheat in an election, and members of both parties voted to impeach. With Clinton, we had private misconduct. Yes, I think probably a crime because he lied about that under oath, but it wasn't misuse of presidential authority. As I said, any husband caught in an affair could have lied about it, and it didn't involve the use of presidential authority. And so we never got beyond our partisan divisions on that. And many of us, and I will include myself, believe that it was being done for a partisan purpose because it didn't reach a high crime and misdemeanor. In the Trump case, and I'll say I've been disappointed because I serve with a number of Republicans in the House who I like, who I respect, who I work with on legislation. And I honestly believe that when this evidence came out, as with in the Nixon administration, we would have it coming together, but it didn't happen, much to my disappointment. I think you have a new opportunity here in the Senate. For one thing, this is a smaller body. You are, as has been mentioned, the greatest deliberative body on the planet. You have an opportunity to do something that we didn't have the chance to do, which is to call firsthand witnesses and hear from them. We have a lot of things happened since the impeachment articles were adopted. One of them were emails that had been released that we didn't know about. See, it's been said that by counsel that the Freedom of Information Act information just shows if you follow the process, you get information. No, they had to sue, and they're still in a lockdown fight over the Freedom of Information Act and the redactions that were not proper. So that's a big fight that's still going on, but we've got information. But most tellingly, Mr. Bolton has now stepped forward and said he's willing to testify. He's willing to come here and testify under oath. And I think we would all learn something. And as Mr. Schiff has mentioned, I think we can structure this in such a way that it will respect the Senate's need to do other business, which we also feel in the House. Let's get that done. And let's see if that kind of information can help the senators come together, as happened in the House Judiciary Committee so many years ago when we dealt with the serious problem of presidential misconduct, abuse of power to cheat an election, when Richard Nixon shocked the nation and ultimately had to resign.
Thank you, Ms. Manager.
Mr. Chief Justice,
The Democratic leader is recognized.
I send a question to the desk for the House managers.
Thank you.
Once again, we are covering the Senate impeachment trial of Donald J. Trump, the 45th President of the United States. There you see a page bringing Senator Schumer's question to the Chief
Question
Justice.
from Senator Schumer for the House managers. Many of our colleagues are worried that if we were able to bring witnesses and documents in the trial, it would take too long. Mr. Schiff mentioned we could do depositions in 1 week. Please elaborate. What can you say that will reassure us that having witnesses and documents can be done in a short time, minimally impeding the business of the Senate?
I thank the senator for the question. First of all, with respect to the documents that we subpoenaed and sought to get in the House, those documents have been collected. So that work has been done. We've been informed, for example, the State Department documents have been collected. Those could readily be provided to the Senate for its consideration. With respect to witnesses, if we agree to a 1 week period to do depositions, will you continue to conduct the business of the Senate? It doesn't mean that we would have unlimited witnesses during that week. We would have to decide on witnesses who are relevant and probative of the issues. Neither side would have an unlimited capacity to call endless witnesses. We would have a limited period of time, just as we had a limited period of time for our opening presentations and for this question and answer period. If there was any dispute over whether a witness is truly material and probative, that decision could be made by the Chief Justice in very short order. If there was a dispute as to whether a passage in a document is covered by an applicable privilege, and if for the first time the White House should actually invoke a privilege, the Chief Justice could decide, is that properly laid, or is that merely an attempt to conceal crime or fraud? So this can be done very quickly. This can be done, I think, effectively. We have never sought to depose every witness under the face of the sun. We have specified 4 in particular that we think are particularly appropriate and relevant here. But we should be able to reach an agreement on concluding that process within a week. So that's how we would contemplate it being done. We make that proposal to our opposing counsel. It would be respectful of your time. It would, I think, be a reasonable accommodation. Counsel says that the Constitution mandates a reasonable accommodation. Well, let's have a reasonable accommodation here. And a reasonable accommodation would be, we'll take 1 week, we'll continue with the business in the Senate, we'll do the depositions, and then we'll come back and we'll present to you what the witnesses had to say in those depositions. And that's how we contemplate the process would work.
Thank you, Mr. Manager. The Majority Leader is recognized.
Mr. Chief Justice, I'm about to send a question to the desk, but I'm going to suggest that following the response to my question and one more Democratic question, we take a 45-minute break for dinner. So I send a question to the desk.
I'm sure there's no objection. The senator from the Majority Leader is for the counsel for the President. Would you please respond to the question on bipartisanship by Senator Alexander and any assertions the House managers made in response to any of the previous questions?
Mr. Chief Justice, Majority Leader, thank you for that question. And in response to Senator Lamar's question about bipartisanship, excuse me, I beg your pardon, Senator Alexander. Senator Alexander, your question. In the Nixon case, the authorizing resolution, this is in the House to authorize the inquiry, was passed by a vote of 410 to 4. 410 voted in favor of the inquiry, only 4 voted against. 232 Democrats, 177 Republicans, and 1 independent voted in favor. In the Clinton authorizing resolution, this was House Resolution 581 to authorize just the beginning of the inquiry. It passed by a vote of 258 to 176. 31 Democrats joined 227 Republicans voting in favor of authorizing that inquiry. That was substantial bipartisan support to authorize the inquiry. In this case, House Resolution 660, which was passed on October 31st, had bipartisan opposition. The votes in favor of the resolution were 231 Democrats and 1 independent. The opposition was all Republicans, 194 plus 2 Democrats voting against. In terms of other assertions that have been made, there are just a couple of points I wanted to touch on. There's been a lot said about House managers have suggested that the counsel for the president have argued that the president could do anything he wants now to solicit any foreign interference in any election. If he thinks it will help him get elected, that's okay, that's the theory of the case. That is absolutely false. That is a gross distortion of what has been presented. And let me make a couple of points about that. There have been questions about the campaign finance laws. And one narrow point that we have made in response to specific questions about the campaign finance laws is simply that information, limited information being presented to a party is not a contribution, a thing of value under the campaign finance laws. And that, it's not just my conclusion, that's what the Mueller report said. When the Mueller report looked into this, said, no judicial decision has treated the voluntary provision of uncompensated opposition research or similar information as a thing of value that could amount to a contribution under campaign finance law. That was volume 1, page 187. So that's a limited point. The bigger point, the suggestion has been made because of Professor Dershowitz's comments that the theory that the president's counsel is advancing is the president can do anything he wants. If he thinks it will advance his reelection, any quid pro quo, anything he wants, anything goes. And that is not true. Professor Dershowitz today issued a statement to show that that was an exaggeration of what he was saying. But let me make the even more narrow point. Aside from what Professor Dershowitz was saying the other night and explaining in abstract and hypothetical terms and academic terms, we have a specific case here. And the specific case here is the one that's been framed by the House managers. And the defects in that case and in their theory of the case are a theory of abuse of power that involves no allegation of a crime whatsoever, no allegation of a violation of established law. Instead, the theory that you can take action that on its face is objectively permissible under the powers of the president and determine that it's going to be treated as impeachable and impermissible solely on an inquiry into subjective motives. That's what the House Judiciary Committee report says. That is a theory that is infinitely malleable. It provides no standard, no real standard at all. And that was one core point that Professor Dershowitz was making, that it is tantamount to impeachment for maladministration. And the other point I'll make is they set the standard for themselves with respect to investigations that they have to establish in order to establish their bad motive, that there's not a scintilla of evidence. There is nothing that you can look at that would suggest any possible legitimate national interest in inquiring into 2016 election interference or the Biden-Burisma affair. They can't possibly meet that standard. It is overdetermined that there is a legitimate policy interest in at least raising a question about those things. Thank you.
Thank you, counsel.
Mr. Chief Justice,
The senator from Delaware.
on behalf of myself and Senator Klobuchar, I send a question to the desk addressed to the President's counsel and the House managers.
Thank you.
Again, we are covering, it's 2.5 hours. This will be the last question in today's second session here. So
The House will go first in answering the question from Senator Coons and Klobuchar. Mr. Sekulow said earlier that the President's counsel would expect to call their own witnesses in this trial if Mr. Bolton or others are called by the House managers. Can you tell the Senate if any of those witnesses would have firsthand knowledge of the charges against the President and his actions?
interesting question.
Mr. Justice, Senator, there certainly are witnesses that the president could call with firsthand information. I don't know that they're the witnesses that they have described so far. Their position is apparently if you're the chairman of a committee doing an investigation, that makes you a relevant witness. It doesn't, or you've all become witnesses in your own investigations. They want to call Joe Biden as a witness. Joe Biden can't tell us why military aid was withheld from Ukraine while it was fighting a war. Joe Biden can't tell us why President Zelensky couldn't get in the door of the White House while the Russian foreign minister could. He's not in a position to answer those questions. He can't tell us whether this rises to an impeachable abuse of power, although he probably has opinions on the subject. But are there witnesses they could call? Absolutely. They have said, Mick Mulvaney issued a statement saying, the president never said what I said he had said earlier. Well, if that's the case, then why don't they call Mick Mulvaney? He should be on their witness list. If Secretary Pompeo has evidence that there was a policy basis to withhold the aid and it was discussed, well, then why don't they call him? That's a relevant fact witness. They don't want to allow the Chief Justice, well, then why don't they call him? That's a relevant fact witness. They don't want to allow the Chief Justice to decide issues of materiality because they know what they're trying to do involves witnesses that don't shed light on the charges against the president. They do satisfy the appetite of their client, but they don't have probative value to the issues here. So yes, there are witnesses. Now, the reason they're not on the president's witness list is because if they were truthful under oath, they would incriminate the president. Otherwise, they would be begging to have Mick Mulvaney come testify. Otherwise, they'd be begging to have the head of OMB, who helped administer the freeze on behalf of the president. Let's bring him in. He'll tell you it was completely innocent. It was all about burden sharing. So why don't they want the head of OMB in? Why don't they want their own people in? Because their own people will incriminate the president. But there's no shortage of relevant, probative witnesses. They just don't want you to hear what they have to say.
Thank you, Mr. Manager.
Besides the fact that Mr. Schumer said, and it's on page 675 of the transcript, that we could call any witnesses we want. Mr. Schiff just said we don't really we can call their witnesses. And that's what he said. You can call their witnesses because under their theory, if we wanted to talk to the whistleblower, even in a secure setting, to find out if he in fact may have worked for the vice president or may have worked on Ukraine or may have been in communication with the staff, that's irrelevant. We can't talk to Joe Biden or Hunter Biden because that's irrelevant, except the conversation that is the subject matter of this inquiry, the phone call transcript that you selectively utilize, has a reference to Hunter Biden. The conversation with bring out through cross-examination. But I just think the irony of this before we go to dinner, that we could call anyone we want except the witnesses we want, but we can call their witnesses that they want. Remember we said the fruit of the poisonous tree? It's still the fruit of the poisonous tree. It doesn't get better with age, as I said. But this idea that this is going to be a fair process, call the witnesses they want. Don't call the witnesses you want because they're irrelevant. Maybe irrelevant to them. They're not irrelevant to the president. And they're not irrelevant to our case. Thank you, Mr. Chief Justice.
Counsel, Mr. Majority Leader, I understand we have 45 minutes.
Mr. Chief Justice, we do indeed.
Thank you.
All right, so that's going to be the break there, and we are going to come back after 45 minutes to proceed with this situation, the Senate impeachment trial of Donald J. Trump, the 45th President of the United States of America. And I'm going to shut this down, but before I go, I thought I'd just do it with a song, and we'll let that song play itself out as we end today's coverage here on Vote Count 2020. I am Karthik Rajan, and this will be the tune we're going to go out with here. Let me get the volume in a meaningful way that makes sense. I don't want it to be too loud since we had it up way loud for the thing there.
Breathe.
I like that suggestion. Breathe.
Ladies and gentlemen, we have the honey drippers in the house tonight. And they just got back from Washington, D.C. I think they got something they want to say.
Give him a chance. Some people say, wait until he's convicted. Impeach the president. Impeach the president. Impeach the president. Impeach the president. Oh, no, we can't do that, man. No. Impeach the president. Shut up, fool. Impeach the president. Why you would do that, huh? Impeach the president. Oh, no. That ain't right. You know that ain't right. Impeach the president. What you talking about, man? Impeach the president. Oh, no. You can't do that, man. Impeach the president. Impeach the president. Impeach the president. Impeach the president.